Thank you very much for watching part 3 of the Contracts Exam Crash Course. Reminder, www.lawbarcoach.com. You can log on there for more information and to book a one-on-one tutoring appointment, which we can do remotely. So let's move right along to issues regarding contract formation. We've already talked about what a contract is, promise, that is legally binding. There's consideration. There's been an offer. There's been an acceptance. So those are the issues so far that we've discussed. If all those are in order, you have a contract. Or do you? There are a couple issues that can prevent the formation of a contract that a court will agree is legally binding. So let's take a look here at definiteness and indefiniteness. A contract needs to be of definite nature, even if the parties are going to pay each other, or a party is going to pay for some sort of promise. They've made an offer, they've accepted, they've done all that, but a court will not enforce it unless the contract is definite in some way. So if a court doesn't enforce it, that means it's not legally enforceable, which means it's not a contract. And if there's no contract, then there are no obligations, it's void. So what do we mean by definiteness? There has to be certain essential terms. If I agree to mow your lawn for payment, and I make that offer to you, you accept, and I show up, well, how much are you going to pay me? We needed to state that. We needed to state what I was doing. What if we said, I'll pay you $10 to show up at my house and do a service? Well, what service? That's an essential term. And this only goes to the material things like payment. What actually am I doing? Mowing the lawn. Okay. We don't have to specify what type of lawnmower or how fast I'll be pushing the lawnmower or something like that. Those can be filled in later on, reasonably speaking. The court wants to know what are the material terms. Get a basis from which the court can then imply fill in the gaps using reasonableness. It's like I said, as long as you say, what service? Oh, I'm going to be mowing your lawn. Okay, and a court will say, well, what does mowing lawn mean? A court will say, a lawnmower is acceptable, but if I showed up with a scissors, I'm going to cut your lawn with a pair of scissors. A court would say, well, no reasonable person would have put that in the contract unless you specified that. So the contract has to have essential terms or it's not a contract, and which touches on filling in the gaps. That, like I said, if I made a contract to mow the lawn, your lawn, and I went over there and did a terrible job, the court will fill in the gaps and say, well, you, even though you didn't state it, you imply that you would do a satisfactory job. There's a difference between the common law and the UCC regarding this. The UCC is extremely liberal with contract formation. We want merchants to be able to enter and execute contracts very easily without having to waste time. And there can be missing essential terms. Believe it or not, you can even fail to put in the price, and a court will figure out what the market rate is, or what the price that the parties have used in the past, something of that nature. And filling in the gaps, one thing the UCC does look towards several different, it focuses on things such as dealings between the parties, industry, trade, customs, things like that. Remember, UCC governs goods, that it's meant to help merchants and people in business buy and sell and trade things very easily, as opposed to the common law, which is more strict. Public policy. When is a contract against public policy. This is broader than simply being illegal. That's very obvious if a contract is for a hit on somebody to murder somebody. That's obviously illegal. No court will enforce that, because to enforce that contract would be to legally enforce something that is against the law. That makes absolutely no sense. But we talk about public policy broader than being illegal, because courts do not want to enforce anything that is bad, that has a bad effect. If something is a broad principle, like an example is the NCAA athletes are not allowed to accept professional benefits or money, gifts for their talents as an athlete. So if an agent were to make a contract in violation of NCAA guidelines with the player, a court would be unlikely to enforce that, even though it technically isn't against the law. The idea is there is an established consensus that we want our scholar athletes to remain amateurs. To violate that is against a broad public policy. A rule of thumb here is to think of it this way. Does the court want to become a party to something that is against principles that society stands for? Because a contract is an enforceable agreement. You need a court to step in and enforce it. And courts will only do that if it is in accord with public policy. A non-compete covenant is if you join a certain industry, or a certain company rather, that's in an industry, you might have to write down that you agree not to compete in that industry after you depart. An example would be, say, a consultant. Say you're a consultant in the beverage industry. You join a company, then you state, if I leave, I'll wait 2 years before I enter this industry again. The idea being that you can't just work there, get all of your clients and contacts, and then quit, start your own firm. There needs to be some protection that the company has, and that's fine. We understand that. No company, they would have to pay you less if they were scared that you were going to take away their clients, or would it be worth starting the company in the first place if they were scared their employers were going to just leave and poach away clients? But it has to be reasonable. There is a public policy that we want people to use their talents and to be able to work for a living. So if someone, in the non-compete clause, it said for the beverage consultant that you will not work as a beverage consultant for the next 10 years in any city in the United States. That is violation of public policy. There's no need for it to be that broad, and it has the effect of preventing someone from entering the workforce that could actually do some good. That's what a blue pencil rule is. A court can go in there and cross out what's too strict. They may cross or change it. Instead of 10 years, let's move it to 2 years, or in certain cities that are just unrelated, but we're going to cross those out, and we're going to turn the non-compete covenant into something that is in accord with public policy. Here are a couple of problems with forming the contract in the first place. Capacity of the parties. They need to have legal capacity to form a contract. If I make a contract with a 5-year-old that he will do something or sell me one of his toys, that will not stand in court. An infant is said to not have capacity to form a contract. The notion is that someone under 18, which is an infant, cannot appreciate the seriousness, the effect of a contract, making themselves legally enforceable, creating a legal duty, all of that. So we say that infants are not bound by the terms of contract. We're protecting them from themselves. Now, we said earlier that contracts are an economic tool. They allow for reliability of promises, allow you to enter a deal. You can then go about your business relying on that the other person has a legal duty. That kind of that's a good thing. But now infants don't have that. It kind of screws them over. If a 17-year-old wants to make a contract in order for some business proposition that he or she has, they can't do it. It's an oppressive rule. Obviously, most people under 18 aren't doing that. But something they might be doing is buying what we call necessaries. A 17-year-old may buy food, clothing, something like that. I mean, if you're under 18, you need to eat, sleep, do other things. Your parents might not always be doing that for you. If a 17-year-old goes to a store and buys what are called necessaries, like I said, food and clothing, that is a binding contract. Because we don't want the person who owns the store to not sell an infant something that's important because he's scared the infant will renege. So necessaries are the exception to infants not being able to contract. Mental issues, it's similar to infancy, but the remedy is a bit limited. Doesn't go to quite the extreme. Whereas if you're an infant, all bets are off. The tests are a little bit determining whether the person was actually able to understand the contract, whether it was fair, whether the other person knew that they had a mental incapacity, along those lines. Intoxication, you could probably guess that it's not much of... You can't get out of a contract by saying, I was drunk. But you might be able to get out of a contract if you say, I was drunk and the other person knew it. But even then, it's difficult. The courts do not want to help drunkards, let's be honest. And the only time you'd want to get out of a contract is if it didn't work out for you. So it would be very convenient if a contract didn't work out for you, you go to court and say, oh, I was drunk when I made it. Tough luck. Restitution. Well, why are we talking about that here? And also, I'm going to look at void and voidable. The idea is that if one of these contracts... I'll put it this way. If someone makes a contract with an infant or someone with a mental issue or what have you, and they actually send a product to them, it's not for free. They can sue for a restitution because they've given up a good. It doesn't mean that there was a contract necessarily, but they can sue for that. And void or voidable comes into play here because an infant can void their contract if he or she chooses, meaning he can disaffirm the contract or ratify it. So if a infant makes a contract for an item, the contract is voidable. It's not void. There is a contract. But the infant, when he turns 18 or she turns 18, they can choose to ratify that contract. And, oh, let's keep it going. I made the contract when I was 17, and I'm glad I made that contract. I'm going to ratify it. Let's keep going. Or they can disaffirm the contract at any time. I made the contract when I was 17. I didn't appreciate that I could have done that. I'm going to disaffirm. So that's why it's voidable. If you look at a contract and you see the person is an infant, do not necessarily think that the contract is void. It is only voidable. It is of the choice of the infant if they want to go ahead with the contract or not. It is not in the choice of the other person, the adult. It's the infant who gets to choose. So here we go, void versus voidable. It's void if there could not have been a contract in the first place. It's voidable if there is a contract, but there is some applicable principle to extinguish the contract, like infancy. Fraudulent misrepresentation and unintentional misrepresentation. This occurs when someone does something that they shouldn't have done when they were representing facts relevant to a contract. And there are two levels of this. One is just plain old fraudulent misrepresentation. I told you I was selling you a Gibson guitar. I knew that it was just an Epiphone guitar, which is a lesser model. And I told you it was a Gibson because I thought it would make you bite, then make you buy it. It induced you into the contract, and you purchased it. That was fraudulent. The contract can be voided. And remember, it can be void, so it's voidable. If you get the guitar and you're like, I love it, I love this guitar, and then keep it. That's fine. But you can void it if you choose to. So if a party intentionally lies to induce someone else into the contract, all bets are off. It is voidable. If a party unintentionally lies, it gets a little more complicated. It happens all the time where people, when you try to enter a contract, you're obviously, there's negotiations, dickering, as they call it, bargaining. The guitar example, you might say, oh, this is one of the best guitars I've ever played. It's excellent. It has low action. The pickups have wonderful sustain. The tone knobs, the wiring, it has 50s wiring, all this great stuff. You want to sell the item. But what if in the course of that, you say something unintentionally that wasn't true? So, like I just said, if you notice, I slipped in there. You probably didn't even notice I said it had 50s wiring. What if you thought it did? You sell guitars all the time. You made a mistake on this specific model. You thought it had something called 50s wiring. It was an unintentional misrepresentation. It actually has modern wiring. Does that mean that the contract is voidable? Well, when we talk about unintentional misrepresentation, it has to be a material untruth, and it has to induce the party into the contract, and there must be reliance on the untruth. So what if this person didn't even know what the difference between 50s wiring and modern wiring was? They didn't care. They didn't think about it. They saw a Gibson guitar. They liked the color. They liked everything else about it. It sounded good to them. And then 2 years later, for whatever reason, they want to get out of this deal. And then they look and say, wow, they show somebody and they're like, this didn't have 50s wiring. Can they go back and get out of the contract because something technically was misrepresented? No, because they didn't rely on that. There needs to be reasonable reliance, and they must have been induced into the contract because of that. This is a higher standard than just with normal fraudulent misrepresentation. The idea being, if someone purposely lies and says something that's wrong, we're going to go after you. The contract's voidable. But if you make a mistake, this happens all the time. Probably every time you buy a car, something they say is maybe slightly inaccurate, right? Every contract, they would open up the water gates to any kind of contract can now be voidable just because if you go back and find some sort of misrepresentation. No. It's only if there is a material untruth that induces somebody into the contract and they relied on it. Opinions and puffery. So if people are allowed to be salesmen when they sell items. If I sell a guitar and I say this is one of the greatest Gibsons I've ever played, it's one of the finest examples of a Les Paul that's ever come through my shop. I sell that guitar and I write, the person notices a month later I said another guitar was the greatest I had ever played. Can they sue and be like, well, you must have misrepresented. You said the other guitar was the greatest. No, that's puffery. That's an opinion, and it's puffery. When you say something's amazing, it's great, it's one of the best, the pickups are, the sustain is, they ring out, it's amazing, you feel like Jimi Hendrix holding this guitar, whatever. You can say all this stuff, but it's just being a salesman. It's puffery. It's only when you get into material items that are more specific. Like I said, if I make a misrepresentation about the number of frets it has, the wiring, something that's much more concrete, tangible, both because It's just the reality that people are salesmen. They have opinions and they give out puffery. We know that. And then B, you know how hard it would be to go back to look at the words that were spoken and to determine if they were actually true. How could you actually determine the truth of whether a certain guitar was the best guitar that you've ever played? That's obviously impossible. By and large, there is no general duty to disclose. If you know something, if I say I'm selling, but obviously this also requires that you didn't make a representation. So if I'm selling a guitar and I say this guitar is in wonderful shape, it's in incredible working order, go home and play it tonight, you will love it. They get home and they play it and there's no wiring inside, and I say, well, I didn't have to tell you that. No, I did, because I made a representation that it could play. And even if I didn't say anything and I'm selling a guitar at a guitar store, there is an implied representation that it can play, that it's merchantable. Why else would I be selling a guitar? I'm not selling it for salvage or something. I'm representing that it's in working order. But what if I said, oh, I'm selling this guitar as is? You've seen that before on eBay, other things, as is. And I know that it's missing, it won't be able to play because it's missing something. Do I have to disclose that? No. The buyer, take it or leave it. You either hire an expert to examine it yourself. I don't know. There is no duty to disclose. Real estate, there are certain statutes or customs that do require that. If you're selling a house, you can't just say take it or leave it. You have to disclose certain things, like if there were termites or water damage. I'm not exactly sure, but you do have to disclose certain items, and that's by statute or custom when it comes to real estate. So that's not the norm. And there are certain instances, this is not all that common, where courts do hold there to be a duty to disclose when one party has vastly superior knowledge, or there's a certain special relationship between the parties. And I'm not just talking friends or something, I mean a legal relationship, a legally recognized partnership. Something, and you would have expected certain information would be supplied to you. And one of the reasons here is because it would be inefficient for a party that has vastly superior knowledge to force the other party to spend the money, time, and effort to investigate. But that is not the norm. It's an argument that you could make and you could throw out, but it is not standard. Duress. Duress is, think of it this is the most basic example. I put a gun to your head and say, sign the contract. In The Godfather, when they said either your brains or your signature will be on the contract, guess what? That's not a contract. It was signed under duress. Holding a gun to your head is an obvious example. You have no actual voluntary will to sign the contract. You're only doing it because you don't want to be killed. Easy example. But it gets more complicated when you look at some. Well, let's do this. Duress generally is defined as wrongful or improper threats. It's always wrongful if you're threatening someone with a crime or tort. I'll shoot you, I'll stab you. Or if it's a criminal prosecution, I'll go to court and tell them to prosecute you for something, or I am a prosecutor and I'll prosecute you. Or even if something was legitimate, I got punched and I said someone, I'll go to court or I'll go to the police and have you prosecuted unless you sign a contract. Use of the civil process in bad faith. If you were suing someone and you're going to take advantage of, you say, I will do certain things, I will request certain documents in discovery that might embarrass you. Now, bad faith that's why we talk about bad faith, because if you say, "Oh, I won't sue you unless you sign this contract," that could be permissible because the parties essentially have made a deal to avoid civil litigation, civil process. But bad faith is saying, "Oh, because I'm going to bring up embarrassing stuff about you in court or request and private information from you." That's bad faith. And the same thing here, that there's an implied duty of good faith and fair dealing, and if you violate that, that's wrongful. Now, duress, those are clear examples of duress. You're essentially, your back is against the wall in these examples, so duress applies. It's wrongful. The contract is no go. And remember, contract is voidable. You put a gun to your head, you get home and you realize, wow, that's a great deal. You can keep it. It's wrongful only if the deal is unfair in these instances. So if the deal is fair, the contract is legitimate. But if the terms of the contract are unfair and these apply, then the contract is voidable. Of course, the first thing you need to determine is the contract unfair. That's hard to do. What's the market rate? How far away from the market rate is this? Are there reasons are there terms that might have affected the price? Are there other reasons? It's hard to say. Let's assume a contract is totally unfair. You sold your house for 50% of what it's worth. These then make duress. A threatened act would harm the recipient. It would not significantly benefit the party making the threat. An effectiveness of the threat is increased by prior unfair dealing. What is threatened is otherwise a use of power for illegitimate ends. These are hard to sort of conceptualize and think about. The idea here is if the facts, they don't look very good. Somebody doesn't look great. But it wasn't a crime. It didn't rise to these levels. But something is still bad, but it's unfair. I have pictures of you in a compromising situation. Unless you sell me your house for half of what it's worth, I'll release them. Something like that. Undue influence, this isn't all that important. This is in a situation where you're under the persuasion of a party, where someone is under persuasion of a party This is unfair persuasion of a party who is under the domination of the person exercising the persuasion, or who, by virtue of the relation between them, is justified in assuming that person will not act in a manner inconsistent with his welfare. This isn't all that important. It's worth noting that language, but this is a much more minor type of thing. It essentially means that someone is in the power to influence someone else, and they exert what is described as undue influence. Because they were in a position of domination, they used that to force someone into a contract. Statute of frauds. The statute of frauds is what it is this. It is a statute. Every state has one, and the UCC, a statute that says certain things need to be in writing. They call it the statute of frauds because if something is in writing, there's less chance that there will be fraud. So it really could be called the statute of writings. The statute that says there must be writings so there isn't fraud in certain instances, the statute of frauds. So by and large, a contract does not have to be written unless the statute of frauds says so. So anytime that you see a contract in a fact pattern where it is not written, an issue is, does the statute of frauds apply? If there's a sale of goods for $499, no, it does not apply. So here are the things that or except when I say exceptions here, I mean they're exceptions to the rule that things don't have to be written. So the basic rule is contracts do not have to be written. So when is a writing required for an action to enforce? I'll write it like this: when is a writing required for an action to be enforceable? When it regards a sale for an interest in land. I'm conveying an interest in the land. And when I say interest in land, it has to be the actual, say, ownership or a lease, something like that, where you actually have property interest. It's not to do something. I'm going to make a contract to mow lawn on land. No, we're talking about the actual sale for an interest in land. Sale of goods over $500. If I make a contract to buy $499 worth of something, it does not have to be written. If I make a contract to buy something over $500, yes, must be written. Contracts in consideration of marriage, that sounds odd. It is very rare. It's essentially saying something like this: if you marry my daughter, I will give you this house. Contracts that cannot be performed in a year. It only is cannot. It may take a year for you to do something, but it is only if it cannot. If I say, can you please build me a house as soon as possible, as soon as you can, build the house with all due speed, and it takes a year and a half to build. Well, it could have been faster. It's only if I were to say, I want you to build me a house, and you cannot start until next year. That means you couldn't perform it within a year. These are contracts that have to take at least a year. Suretyship contract, that really means just is a promise to a creditor to be accountable for the debt of another. If Marty doesn't pay you, I will, type of a contract. Ratification of a voidable contract. We said above that if an infant were to ratify when he turns or she turns 18, say, oh no, I do want to go ahead with that contract. The ratification of a voidable contract has to be done in writing. Exceptions. This promissory estoppel, that's not the exception there is not worth getting into right now. Exceptions to the exceptions. The part performance doctrine. If you actually go ahead, well, let me backtrack for 1 second. The statute of frauds, the whole point of it is not just because we like writings for the sake of it. It's to minimize fraud. So if the parties actually start doing the thing that they promised to do, there's chances are there wasn't fraud. Because they actually wanted to do it. If I bought a guitar for $1,000 and we never wrote anything down, he handed me the guitar, I handed him $1,000 and went home, there's no fraud. We clearly wanted the deal to happen. But if no guitar was ever exchanged, and I was sued, they said, oh, you bought a $1,000 guitar. I said, well, no, I didn't. And where's the writing? It's only if we started to perform. What is a writing? A writing has to identify the parties involved. It has to state the main terms of the agreement, the material subject matter, and it must contain a signature. And if you notice, I have signature, not signatures. It only needs to be signed by the person the contract is being enforced against. Why? Because if we're in court and someone says, no, I didn't buy that, well, your signature is here. Oh, it's only that person's signature that matters. Only the person who in court is being like, no, there was no contract. If the other person's in court, whether he's bringing the case to court, he obviously wants there to have been a contract, regardless if he signed it. It's only the person who is enforced against that we're concerned with here. The UCC, and once again, has relaxed requirements for everything in a writing. Certain things can be entirely missing. Certain material subject matters and terms can be entirely absent.